Welcome to Dodging Bullets, the Insolvency Practitioner's Guide to Surviving the Week. Now, as some of you know, it has been the annual Insol conference in London, which means that our international colleagues have voluntarily submitted themselves to tube strikes and a heady mix of technical discussion and social engagements at the Marriott by Hyde Park. I had a really nice quote from a Florida-based lawyer on this. It's all about shrinking the world, which I quite like. So this is a good opportunity to delve into our international working practices and the challenges faced when we're dealing with differing custom and practice. I'm therefore delighted to be joined by my colleague Geraldine Valdez, an experienced insolvency litigator formerly based out of San Diego, which wasn't until 2020 when you returned to the UK. So good morning, Geraldine.
Good morning, Frank.
Now, your CV, which I happened to cast my eye over on LinkedIn earlier, such a rich tapestry of names from Hovey, Kirby, Hornton, Hahn, Procopio, Corey, Hargreaves, Savage, and then your own firm. Prior to that, you obtained your Juris Doctor in Law from Berkeley, and as I was going over this, I found myself thinking, I will resist the urge to call you Dr. Valdez throughout the recording. Now, I suppose, start of 10, was there anything in particular which drew you to this sector after your legal studies?
No, I graduated from the University of California at Berkeley, as we like to call it, School of Law in 1994. When I came out of law school was during a recession, and I had all sorts of plans to do different types of law, but there were no jobs available, and all the corporate and transactional attorneys were pounding the pavements because they'd been made redundant, and the only jobs available were in the insolvency field. I wasn't real happy about that at the time, but having joined that area of practice, I found it the most collegial. It was a small specialty niche. We had our own courts. We all knew each other. All the bankruptcy lawyers in San Diego knew each other. We had events together, socialized, worked together. So I decided I'd made a good choice.
Excellent. And my apologies to Berkeley. I suspect there will be a few more incidences in this recording of different pronunciations. As a disclaimer for anyone who doesn't know my background, I should also point out that I spent a number of years at an American school in Colombia, Colegio Bolivar. A big shout out to all of them. And so I'm not unfamiliar with the language, custom and practice of US law, and spend a reasonable amount of time delving into different jurisdictions in that area. So maybe one of these days I'll get around to hosting one of these events in Spanish, which would be a good professional challenge. Anyway, let's move on with the central premise of this. This is about dodging bullets, so it's about the hazards and obstacles faced by the profession. And because we're looking at international collaboration and using sort of US and UK as an example here, we're sort of starting with the, I suppose, communication as a starting point. Now, it has often been said that it is two nations separated by common language. You could argue that's just simply England and Scotland rather than saying the US and the UK. But it did strike me that linguistically, there's always going to be a bit of a contrast. I happen to be looking over a judgment, not insolvency related, but it was about the Texan challenge to the Decalogue being posted in a school classroom. And it's referenced the matter being ripe for litigation. And I thought it's such a nice little nuanced phrase to sum up that something is relevant and the evidence has been established and there is a claim to be looked at and it is therefore ripe as opposed to unripe. And I wondered, as a starting point, whether you found that the linguistic differences, how apparent they were when you moved jurisdictions from the US to the UK.
Well, I would actually say that's been one of the biggest problems. I will be working on a project here in the UK and read about certain claims and other procedural matters in the insolvency practice here and think, oh, God, I don't know anything about this. But then down the road, I'd realize, oh, well, that's actually one of those. And well, just to give a classic example, we go into court with applications. In the United States, we go into court with motions. So when people were talking about applications, I didn't realize they meant a motion. So there's a lot of vocabulary things, linguistic things that make it problematic. It's almost like speaking a foreign language.
Do you think that the US sort of language and approach, do you think that's richer? Do you think it's more useful to have greater variety there? I sometimes wonder whether we're all victims of the plain English campaign and there's a sort of a general dumbing down of language used in UK jurisdictions. Uh,
Oh, absolutely not. I think the reverse is true. I wouldn't say America has dumbed it down, but one of the hardest things I've found coming back to the United States is if I read court opinions or lengthy briefs, they're really sort of narrative and chronological, and they flow, and there's loads of adjectives, and the sentences are long, and I find it hard now, although that's what I was raised with because I was raised in England. I find it hard now to concentrate and keep my focus on them. Whereas in America, we're taught snappy sentences, very short, lots of headings. Everything should be organized very and so in fact, I wouldn't exactly call it dumbing down. I would call it more making it easier and clearer for people to read and understand.
I suppose my reference to dumbing down was actually about the plain English campaign in the UK and whether the inverse applied.
Oh no, we have the plain English campaign. The plain English campaign is very prevalent in the United States as well. Yes.
Okay, so from that point of view, the immediate distinction there would be a sort of conciseness in language in the US that you might not then see in the UK, which is interesting because I think judges would always prefer to have a sort of concise version. Anyway, moving on, the one of the other points that's always been sort of brought up is the attitude that you might bring to litigation, either in the US or the UK, and the approach. So I suppose there's two areas which fall under this, one of which is about the systems and the approach of, say, insolvency law. And then separately, there's the attitude and approach brought by the individuals as litigators and how they both feed into each other. So I suppose my impression has been that there is a more pro-debtor, pro-director culture within the legislative frameworks in the US, and the UK is broadly more interested in creditor rights and the ability of creditors to sort of engage with the process. Would you say that's accurate?
Definitely would say that's accurate from my observations. I would even go so far as to say there's a sort of an intuitive sense over here that debtor bad, creditor good. And I've found over my 20 years of practice that there's bad creditors and there's bad debtors and bad directors, and there are also the converse of that. So I don't try and go in there being prejudging people. I think we have a very strong attitude in the US that a debtor, especially a debtor corporation that's in trouble, is a company that got into trouble. We don't immediately snap to the conclusion that the director's done something wrong or bad. He may not have been the greatest director in the world, but he's not always intentionally trying to ruin his company. So I think that's a very strong difference.
I think that's interesting because there's frequently the discussion about whether there's a stigma to a business failure or a bankruptcy. And I promise I will only mention the present incumbent in the White House once on this recording. And it is simply to reference his 6 sort of bankruptcies or business failings and the other failed ventures he has. It clearly hasn't been a barrier to his success, despite the fact that a lot of those come with sort of fairly lengthy explanations on how poor his business practice appears to have been. I'm speaking very carefully here. I don't want any of this to come back on me later on. So if that's not a stigma, I suppose, are we getting the balance right? Does that mean that the US is less risk averse or more tolerant of business failure? And does that also, I suppose, mean that there's a greater potential prevalence of fraud within that jurisdiction?
Well, I think it's a much more proactive decision. It's here we have a company in trouble. We've got creditors. How do we fix the problem? Can we sort the company out and have it continue to operate and fix the issues that have made it put it where it is? It really is. The whole mindset is we're going to give this debtor corporation a fresh start. Whereas over here, it's like, well, here we've got now a new case in an administration, and how can we sell all the assets and close it all down? I've not, in the 6 years now I've been working in the UK, I've not seen an administration which has resulted in the business continuing to operate under the same precepts that it was operating in prior to the administration. I've only ever seen sort of liquidating administrations where assets are sold.
I suppose from that point of view, the rescue is primarily the purpose. Certainly the Enterprise Act, when it came in, was geared around the idea of a rescue recovery. I mean, in its very own name, the Enterprise Act is based around the idea that to facilitate enterprise and economic growth at the state level, you need to accept business failure and encourage the ability of people in business to pick up and carry on trading and to continue and not be so hampered by an insolvency process that they can't start again. So if the perception is that it's more creditor focused, I'm not sure that was the intention with the legislators when they started. But I suppose moving on, if it's a very debtor-led process, but there's a lot of creditor rights being established, clearly that leads to a greater preponderance of lawyers active in the US. And I have a sense from a procedural point of view that there is more court engagement in the US, whereas in the UK you might see more matters which can bypass court engagement because they can be dealt with simply between insolvency practitioners and businesses and individuals. So if there is more court engagement, presumably then there is a greater reliance on lawyers.
That would be absolutely true. There is definitely a greater reliance on lawyers. We have a system whereby we have actual bankruptcy courts. And as soon as anybody files personal bankruptcy, a corporate liquidation, anything of that nature, it will be randomly assigned to one of the bankruptcy judges in that jurisdiction. So that bankruptcy judge now follows that case from cradle to grave. There are way more hoops you have to jump through, whereby certain things have to be approved by the court. For example, if I'm an IP and I want to hire a law firm to act for me in a certain case, I have to file an employment application, and they have to be witness statements from the law firm that they don't have a conflict of interest, and so forth and so on. I mean, they regularly get approved. It's pretty much a rubber stamping exercise. Fee applications, now they're not such a rubber stamping exercise. You can't pay yourself fees as an IP or as a lawyer representing an IP unless you have submitted a fee application to a judge who will pick through it with a fine tooth comb and ask you why you just spent 0.1 units on such and such a task. So there's a lot of administrative stuff that's handled by the court. The court has to approve bankruptcy sales or insolvency sales of businesses or residences. So, everything's handled by the judge from beginning to end.
I think we'll come into some of the detail. I just wondered whether that creates an issue where you have a lot of armchair lawyers who perhaps have passed a state bar exam and perhaps aren't properly competent. And I suppose, secondly, does that mean that there are some jurisdictions where you might have more lawyers or fewer lawyers of different experiences or different sort of qualities coming to the fore?
Oh yes. Well, I think you can first of all, you can separate personal bankruptcies from reorganizations. There are loads and loads of what we call Chapter 7 personal bankruptcy lawyers who are usually sole practitioners and have very little experience. And for the most part, it's a form filling exercise. So there was also a huge scandal because the United States Trustee's Office, which is the equivalent in America of the Insolvency Service, went after all these paralegals that were advertising their services to prepare bankruptcy petitions and schedules for debtors, and that's not allowed. So the Trustee's Office were going after them. From the corporate side, yes, we have very experienced, very good quality lawyers, and there are more depending on which jurisdiction you're in. For example, Delaware. Delaware is a state that has very favorable corporate laws and very favorable bankruptcy laws. So any corporation that is going into a proceeding will find a way, if they can, to file the bankruptcy in. Other jurisdictions have become very popular too, like the Southern District of New York, some court jurisdictions in Florida. and others have become less. I mean, my jurisdiction, San Diego, we used to get pretty good cases, but now it tend to get carpetbagger lawyers coming down from Los Angeles and taking all our cases up there. So, yeah, obviously that has now resulted in a decline in the number of bankruptcy lawyers in San Diego. So it moves around.
Interesting. I'm particularly interested in that point about the trustees service going after legal, or sort of going after paralegals, because of course in the UK we've had Silex versus Mazur as form of litigation on whether legal executives should be allowed to carry out certain legal processes. And in a scenario like this, where there's a broad range of legal expertise and services being offered, it feels like the system ought to be a little bit more nuanced as to what different legal qualifications can deliver. But I find it interesting, very interesting, that both in the US and the UK there's been similar attacks on the sort of legal support services and the professions in there. Let's sort of move on a little bit into some of the other processes which come into play. I mean, we have the sense, we've just been talking about the pro-debtor versus pro-creditor aspect, the more court-driven controls, which to my mind reminds me a little bit of Scotland. There's more sort of referrals back to the court. There's more deadlines you need to think about. How does that then play through into the real terms, sort of real term approaches you might have? I mean, in my mind, this feels a little bit like a game show. This is a little bit like Mastermind with a small hint of Call My Bluff. So if we just rattle through how we might approach different things differently, and then we'll sort of circle back round to what works better in the US that perhaps the UK might learn from in their approach to this. So if we let's start with something we've already touched on, which is administration processes. Obviously in the UK, administrations are there primarily to try and rescue the business, but with mixed success. And there is a prevailing view from some members of the judiciary that perhaps administrations are being used inappropriately for other purposes, or aren't really achieving the initial intention, which is to rescue on a very short leash, i.e. try and get it done within 12 months. So what would be the analogous US procedure that you would use?
Okay, so the analogous US procedure is a reorganization under Chapter 11 of the Bankruptcy Code. Each of our different types of bankruptcy proceedings is assigned to a chapter in the code, and they're sort of commonly referred to as Chapter 7s, Chapter 11s, Chapter 13s. And corporate reorganization comes under Chapter 11. And the major difference between a Chapter 11 and an administration is when a company goes into Chapter 11, the directors of the company, management, remain in control, and the debtor becomes what's called debtor in possession, because the company is still in possession of its own business. Management continues to operate. It has very strict oversight by not only the US Trustees Office, but of course the court, and creditors committees play a very important role. But I think it has two advantages over our system. I think in general it's cheaper because you appoint an IP to run a company that they know nothing about. I mean, I'm not blaming them for that. There's no reason why an IP could know how to run every specific business in every niche market or know anything about the company itself. Whereas management's already on board. It may not have done a good job, or it may have had things that failed it. But there again, we get back to management's not bad. That's the attitude. They're not bad. They just have made mistakes. Now we're going to try and put them on the right path. So they continue to manage. And again, so the company, not only is it rescued, but it continues to operate in a streamlined way, one hopes. And you get to the end of a reorganization, you present a plan. This is what we're going to do. Maybe we're going to sell off orphan assets or divisions of the company that are not making money, or real property in order to make money to keep going. Here's a payment plan so we can repay creditors. Or maybe it doesn't go very well and it has to be liquidated, and maybe an IP does get appointed at the end of the day because the directors were bad and they acted recklessly or fraudulently, in which case an application or motion would be filed to appoint an IP to oversee it. But I think keeping management involved is a much better way to allow the company to recover and continue in its business.
I need to stop myself from automatically thinking of directors as just being very naughty in a sort of Monty Python sense. Is it possible within that to investigate fraud? For instance, would you expect fraud to be investigated in that Chapter 11 procedure, or would that only be available if there was an exit into a liquidation?
Well, fraud's available, but as a practical matter, if you're talking about fraud against directors, as a practical matter, if the directors are still in charge of the company, it's unlikely that they're going to sue themselves for fraud. There is an escape hatch for that, because during an insolvency, much as here, at a certain time when a company becomes insolvent, the duty of directors passes from shareholders to creditors. In the shareholder situation, a shareholder can go into court and sue on behalf of the company, can sue management under what's called a shareholder derivative action. And the proceeds from that lawsuit would go to split between all the shareholders because they're suing on behalf of the company. So, of course, when you pass into insolvency, now the creditors take that role, and the creditors could go, a creditor, for example, could go to court, sue the directors, and foreseeably get a judgment which will benefit the company and hence all creditors. So that is definitely a way that would be done. But of course, in the normal Chapter 11, you will not have an IP there to bring these fraud claims.
That's interesting, because you have a rescue which might then try and take what would have otherwise been considered a sort of a fraudulent trading scheme and then try and exit via a rescue procedure, still under the director control, which then serves to conceal evidence or to change the way you might approach the claim, because the information won't be available to the IP in the same format and the directors will have had an opportunity to conceal it. But I think this probably reflects the UK versus US attitude again, which is that
it does.
You might expect an IP to be looking for that information from day one. And I can certainly think of matters that I've worked on where from the outside you're trying to promote a rescue procedure, but there is a strong level of creditor interest in a misrepresentation, potential breach of constructive trust, and other matters which they want to be looked at the same time as a rescue procedure being implemented. How about the involuntary procedures? I love the concept of an involuntary procedure, sort of it's happening to you. Obviously, we have the court-based winding ups in the UK, and in the US jurisdiction, I presume there's a similar sort of format where creditors can petition the courts for the insolvency of a company.
There is. It's rarely used. In fact, in 20 years of practice, I don't think I ever saw an involuntary liquidation. And the reason being that the statute is very strict. It says 3 creditors have to get together. You can't start a winding up or a liquidation based on one creditor. It has to be 3 creditors. There is a floor in terms of the amount of money of claims that these 3 creditors collectively have in terms of a percentage of the actual corporate debt. So you can't go in with some small debt. And I've had one here in England where the creditor was owed £10,000 and managed to put an entire development company into real liquidation, which I find extraordinary. But there you go. So creditors don't do it, but the main reason creditors don't do it is, first of all, they can never sort of get their act together and get 3 of them on the same page. But second of all, if you get it wrong and you bring a winding up petition and the court denies it or dismisses it, you're subject to lawyers' fees, you're subject to potential damages to reputation of the company, and worse still, if they think there's been anything willful or intentional, you're subject to punitive damages. So people just don't do it.
Punitive damages, sharp intake of breath, the risk of I suppose within a very litigious jurisdiction of someone seeking to punish a application which might have otherwise been brought in good faith, but simply the court has determined that it was not. I can imagine that would put people off. And I suppose lawyers would then also counsel against it. So lawyers would say, well, actually, you're likely to be on a hiding to nothing if you try and bring this particular claim. There's a limited prospect of success. There's a limited prospect of recovery. And the court will presume more efforts need to be made towards a more collaborative procedure or more sort of direct-led procedure to try and generate some sort of positive outcome. And it's always interesting thinking there needs to be a de minimis which is so high because within UK jurisdiction we have our methods of sort of bringing forward demands and trying to enforce, and winding up a company or presenting a bankruptcy petition against an individual is always seen as the last resort. It is frequently the worst way of recovering any kind of debt, but it is there to take it out of the control of the individuals and put it into the hands of somebody who objectively will assess whether there is a recovery to be made. And to my mind, it feels very almost perverse that remedy isn't available to the smaller creditors within any jurisdiction. But there we have it.
Just to spin off that, if I may, you really don't see many corporations go into liquidation at all, because the voluntary liquidation route. I used to advise my clients. I'd have clients come to me and say, "Oh my gosh, the creditors are banging on my doors. Things have gone wrong. Should I go into a Chapter 7 liquidation proceeding?" And I'd say, "Well, why do you want to do that? I know it's annoying that creditors are banging on your door, but you're not personally liable because company is only liable. So close the doors and go away and shut your company down."
Yes.
Because it's the same effect, and you're not going to have some IP appointed who's going to poke into the way you run your company and what you might have done and what you might not have done. So that's generally what insolvent companies do in the liquidation sense. They just shut the doors and go.
Yes, we'll just walk away. Interesting. Moving into the area of discovery and disclosure, I know this is a bit of a hot topic for us because of the information that's needed in international matters, or certainly international investigations, and the ability to access information in any jurisdiction, not just the US, is key. And different jurisdictions have different publicly available information, and the ability to access that information can make an enormous difference to how well an investigation proceeds, particularly if assets are stored overseas or if there's multiple companies operating in different jurisdictions. So what's the key distinction between the US sort of discovery process and the UK discovery process from your view?
Much more transparent in the US. Now, suppose you, Frank Turnbull, just file some proceeding over here in England, and I think, oh gosh, you may have some court cases and stuff in the United States. I have a universal, nationwide password where I can access any federal court in the entire United States, and I can search for Frank Turnbull, and I can say, aha, somebody sued Frank Turnbull up in Connecticut, so I know that. Also, if I know where Frank Turnbull might have assets, say I think Frank Turnbull has assets in Los Angeles, I can similarly go to Los Angeles State Court, but I can't do a nationwide search. I have to know exactly what state court that would be. But again, I can get into Los Angeles State Court website, get onto the docket. I can see everything that's been filed, all the evidence that's on there, all the applications that have been filed, the particulars of claim. So it's all open to the public. Whereas here, it's terribly difficult to get, especially court documents and evidence that has been used in a public court proceeding is not allowed to be disclosed to me necessarily, which I find strange.
That's interesting. Is there any sort of time limit on this? I mean, we know that across the world there are various efforts being made to digitize and make available court information and other public registry information, and in some cases they are possibly lagging a little behind. So is it something which is available sort of going back 20 years, 30 years, 40 years? Is there a digitization program? Are there any restrictions on what might be available?
Well, for current cases, it's certainly been going since 1994 when I've been practicing law. That's when it first started to come in, and the courts have diligently tried to back up the system with archived cases and things like that. So I'm not sure what the status is now, but anything in the last 20, 25 years is fair game. You can find it.
How about other publicly available information? Say, obviously, we have the land registry here. We have various different registers for probate, for county court judgments. Is it as easy to find out information about property ownership, for instance?
Well, yes, it's as easy, except you need to have some clue about where these things are, because the federal court system is the only system I know that's national. If you want to find out about whether a corporation, there's no equivalent of Companies House. Each state has a Secretary of State's office: Delaware, California, Washington. And if you want to find out about a company, you go into the Secretary of State's office, and you will get a docket, much like you do in Companies House here, with all the information about your company. But you have to know that company's, or else you're just going to take potluck over 50 states and try each of them by turn to see whether that company's incorporated in that state. Land registry is even harder, because title registers are kept by county in a specific state. So if I'm looking for Frank Turnbull's house in San Diego, I have to go to San Diego County Recorder's Office and check all the registration documents and title documents there. But I need to know then that Frank Turnbull's house is in San Diego. Otherwise, again, not only would I be going over 50 states, but I'd have to go through all the counties in those states.
So on the one hand, incredibly transparent. On the other hand, actually not that transparent at all, in that there's no centralized register that would then allow you to access information that would be there and useful.
I don't know how you could do that, because states are governed by state law, so especially property laws, and they're not governed by federal law. So they have to. I know the county thing's a bit specific, but even so, even county. That would be probably because property taxes, which were the equivalent of rates, etc., are governed by the counties in which the property sits. So it seems to make, that's probably why they have all the property records kept by county.
I suppose that would be an entire separate topic in itself, is the overlay of the sort of the primary law, federal law, state law, county sort of specificity. And it once again comes back to the need for legal representation, which I suspect might be a bit of a conclusion at the end of this. How about the disposal of assets? We've talked about the sale being subject to court participation. This feels a little bit bizarre to my mind. That the court would want to be involved in something which is presumably a sort of a commercial process. Can you think of why it's so customary for the court to be involved in the disposal of assets?
Well, I think it's because during an insolvency sale, there are no real reps and warranties given. Property is bought as is. And again, you're in a very litigious country. So you're trying, by having a bankruptcy court, having any sale blessed by a bankruptcy judge, you're getting a court order which protects IPs against future litigation. Also, it's conducted as a kind of an auction. I mean, the trustee finds a stalking horse buyer, puts together moving papers, an application, what have you, to have the sale approved. Then it has to be noticed out in the newspapers, or well, not newspapers, that's very ancient. I'm sure there's online ways for doing that these days. And saying that there will be a hearing in the bankruptcy court on X date to sell this property. Anyone who would like to come along and overbid, show up. And then you go down to bankruptcy court on the day of the hearing, and you have a little mini auction there. And I've participated and even sold properties on behalf of IPs where somebody showed up. I mean, I have a recollection of one that we could not sell this company. We had to sell it. Was not going to be able to continue the way it was. We couldn't sell it, and so we'd come up with some plan of reorganization whereby shares were going to be given to creditors in return for the company, and it was all very complex, and it wasn't very satisfactory because money wasn't involved. And we were going through the hearing, and the court doors opened, and these two handsome young men in Armani suits marched into the podium with a check for $250,000 and said, "Here's a non-refundable $250,000 check for which we will do, and then we'll do our due diligence after, but it's non-refundable." And suddenly the dynamics of the courtroom shifted, and lawyers who were sort of in cahoots with the original proposed buyer moved over to stand by the new people that walked in. It was all very interesting anyway.
I mean, we would never get that past any sort of anti-money laundering checks. The whole idea of that, and the idea of judges actually being able to have the capacity to get involved in sale processes is absolutely bizarre. And I'm sure there's other nuances to how property is then viewed within those scenarios. I know that there's one of the areas that we had sort of talked about in advance of this is exemptions. And I think that the exemptions which we are used to seeing in UK jurisdiction, which are sort of basically tied around, can you still carry out your job? Can you still generate an income? Can you still be involved in it? That's what's protected, as well as sort of the protection of some pension plans. But I get the impression that with such a debtor-focused procedure, the exemptions in the US are probably broader.
Well, the most important one is the homeowners exemption. The amount of money that can be exempted is dependent on state law. You can only do this on a house that is your primary residence. You can't exempt any kind of property asset that you have, but because it's called a homestead exemption, that allows the family to stay in the home. So you can exempt equity up to a certain amount. Until fairly recently, the states of Texas and Florida had an unlimited homeowners exemption. So rich people would go and buy $1 million, $2 million, $3 million properties in those states, and if they filed for a personal bankruptcy, they would then be able to exempt them completely.
This is utterly insane. I would just like to put that out there. I think this is the most bizarre way of protecting people from any sort of sense of responsibility or accountability I have ever come across. I am absolutely aghast that those sorts of exemptions exist. But, you do learn something every day.
So was the legislature, Frank, and I don't know what the changes have been, but they have been changes, and Texas and Florida no longer have unlimited exemptions. However, I will say that, again, over here, if you rip someone's home out from under them, what happens next? They go to the council and say, I want a council house. And next thing, the taxpayers having to fund their lifestyle. So someone pays at the end of the day, always. So is that better, or is it better to let the homeowner stay in his home?
We make a point of never getting political on these podcasts. We don't go anywhere near. We don't go anywhere near.
I'm saying what the alternatives are. I'm not trying to get political, but somebody pays for this debtor who's lost his home.
Yes, that I suppose is the point. But the creditors might then argue, of course, that if there is an asset and that asset has sizable value, and if it might be the sole asset, is it fair that it should be exempted to the extent that there is no then sort of payment back to those people who are legitimate creditors? Anyway, I think we could probably speak about that for quite a long time. In terms of I'm very aware that this is running on, and I think that we might need to speak separately about how insolvency claims are advanced through different procedures and where the overlaps are and where there are analogous claims that can be pursued. My sense is that anything which could be pursued in the UK would probably be pursued in the US. It's just slightly different timeframes and slightly different windows of opportunity that exist. There might be different approaches to limitation, for instance, and there might be different burdens of proof on different parties. Are there any which have stood out to you as being where there's a greater divergence, say?
Well, a preference action, say. Insolvency Act number is that 240? Not sure now. In the US, it's code sections 547, but let's not get bogged down in code sections and act number sections. In a preference action in this country, one of the things that the IP will have to prove is that the director intended to prefer the creditor who received the preference. In the US, the burden flips. In the US, if you got money if you're not connected, if you got money within 90 days before the filing of the proceeding, you are presumed to have received a preference and you get sued. And then the burden becomes on the creditor to produce there are a number of defenses. One of them being, well, we incurred this debt in the ordinary course of business. One of them being, well, after we incurred this debt, we then went on to extend more credit to the debtor for future business. As I say, there's a number of different defenses, but there's no burden on the IP to prove intent. So I think that's a big one.
That feels like a great divergence from common legal practice to say that you don't need to intend to do something as part of it. How about the sort of our different approaches to international working? I think that's the very key thing, particularly with the week that's just happened. I know that there's Chapter 15 in the US. We have our cross-border insolvency regulations, which have settled down post-Brexit. Is there a sense that the US are comfortable working in all other jurisdictions, or do they expect other jurisdictions to sort of bend to their will?
I would suggest, well, I mean, the model laws on insolvency that came out of the United Nations International Tax. I was actually a delegate to their meetings, so I got to go and participate and negotiate the language of the model laws. But technically speaking, they were supposed to be mirrored all across the world. So the Americans consolidated the UN model laws and turned them into Chapter 15. And we took them over here, and I think we just call them the cross-border insolvency regulations at the moment, although I understand that there are moves to kind of draft different legislation that's more tailored rather than just adopting the models laws as is. Yes, I would suggest that Americans probably do think that when they show up in another country, they're going to be treated exactly the same as they are in their own country, and they're not, because if a UK company started an ancillary proceeding under Chapter 15 in the United States, they would have to abide by US bankruptcy law standards, and vice versa. I'm assuming vice versa.
Given you were working in San Diego, you must have had a reasonable amount of interplay with, say, the Mexican border or Mexican industry, if there were sort of matters which were operating on either side of the border. Did that come into play at all in your experience?
It did. Most of the work, I don't know that I ever had any cases post. The model laws in Chapter 15 only came into effect in 2005. I think most of the Mexican cases I had, no, one of them was after 2005. We had a lot of work for IPs who would have cases involving directors and headquarters of companies that are in San Diego County, and being with the proximity to the border, their manufacturing facilities, their maquiladoras, as they closed, would be over the border in Tijuana. But it was hard to liquidate them because Mexican laws, corporate laws are really strict. If you don't pay your employees on time, or you don't pay your taxes on time, the federales come in with machine guns, break down your doors, and seize everything. So there's never anything left for the American IP at the end of the day. So that was always a bit of a problem. I had another case in 2008 involving a property in Mexico, a house. I represented a client who had bought the house. He was a Mexican citizen. He bought the house from an American who was a bankrupt, and he didn't know that. So the bankruptcy IP or trustee wanted to get the house back, and ended up selling the claims to an American company, who then sued my client. There was a huge lawsuit. I'm very hard to keep this simple. And the judge ended up awarding the American company the house. And Mexican law does not allow American companies to own property, in legal title to property in Mexico, in what's called the restricted zone, which is coastal zone and areas close to the border. The procedure is if you want to own property there, you get a Mexican bank, to become a trustee and hold the legal title. And then you, Mr. Foreigner, just have the benefit of the beneficial interest. But the judge in America, as you were saying earlier, Frank, was expecting things to work the way in Mexico as they work in United States. And she was absolutely furious because my client wasn't complying with the judgment, because my client couldn't. And she just seemed to refuse to accept that he couldn't just sign a transfer deed and turn the property over. So, yes, I mean, there are a lot of problems. And that actually seems like it would have been a case that might have been a good case to bring in Mexico under the model laws, because Mexico have adopted the model laws. And the irony is that this particular judge was the woman who had written the book on Chapter 15 and the model laws, but she didn't seem to want to employ them in her own courtroom. So
that sounds interesting and incredibly challenging, and I'm sure is even more challenging now. So, I mean, thinking about this sort of the style and the substance of the way that US litigation happens abroad, with a broader range of litigators, say, and with a more direct, possibly more combative approach. From your experience being back in the UK and thinking back to your career in the US, what do you think you would bring over? Are there any sort of tweaks to approach that you would like to see in UK litigation or in sort of access to information over here?
Oh, definitely the transparency. And the tools we have. We have a Federal Rule of Bankruptcy Procedure 2004, which allows anybody who's in a bankruptcy proceeding, including third parties, banks, your wife, your business partner, you can summon them into court, put them under oath, you get a court reporter, and you interview them. And it's really a fishing expedition. It's fair game. You can ask pretty much anything about assets, liabilities, anything about the company, whatever you want. And it's admissible in a future trial because it was on the record. It's been recorded by a court reporter. And over here, it's such a struggle to get information from anybody. Banks don't want to cooperate when you ask them for bank statements, or the other third parties will say, "Oh, you're not entitled to those documents." So that would make my life so much easier if we had a more stringent discovery practice. But the downside, of course, is it makes everything a lot more expensive.
Yes, and that is the cost. So this sort of, I suppose, brings me on to my concluding point, which is, as per the podcast, there's always a bullet to dodge. And I think here, if we're talking about working in a foreign jurisdiction, be it dipping your toe into sort of recovering US assets when you have a UK-based claim, or vice versa, if it's US litigation coming over to the UK, what's the key takeaway? My key takeaway might simply be, don't think you would ever be able to save any money here. You have no choice but to lawyer up and make sure you have the right lawyer in the right specific jurisdiction, the right state with the right level of experience to be able to find the best outcome. There are no shortcuts to proper legal representation.
That would be my feeling as well. And of course, the conundrum there is that if you're going to hire a lawyer in a foreign jurisdiction, they're not going to want to work on a CFA. So you're going to have to find money to pay them.
Yes, it always seems to sort of turn around to money. But then again, in these matters, particularly in matters of international cooperation, it might be possible to find good partnerships there, and certainly people that you can work with on matters, and at least find a way of practically funding the litigation you will be working on. It's been really interesting just going over that from my point of view. It's funny to see that there can be so many divergences in terms of approach and different outcomes, and it would be really good, I suppose, to compare and contrast two different cases which perhaps have had different outcomes, or would have had different outcomes if they'd been subject to investigation or sort of insolvency proceedings in the different jurisdictions. I like working with the guys in the US because I find it's really interesting to work with people who are so direct and to the point on what can be achieved. And I think the biggest challenge is having a viable and experienced network of parties that you can go and speak to for that advice.
I've had one case over here, actually thinking about it, where it was a US case. And one of the biggest claims in the case was HMRC. Well, HMRC have a relationship with the IRS in the United States. And so HMRC asked the IRS to go to court and demand documents and discovery from a party living over there who had assets over there. So the IRS did all HMRC, ergo our work for us, trying to get the documents in the United States. So that's a resource. If there's tax implications and there's taxes owed. And HMRC finds this case worthwhile being involved in.
Yes, I suppose that's a good point as well, just to end on, is that just because we might find that there's issues with information sharing at government level, and certainly between government institutions, such as the police or HMRC, there may be more information sharing happens there, which can be used beneficially by IPs in either jurisdiction. And once again, I mean, a common message for me, it's one of the soapboxes I like to leap up onto enthusiastically, is greater transparency, greater information sharing between stakeholders where there's a common end is generally beneficial for all. And the first thing to do is work out who can help and what's in it for them, I suppose. So in a scenario like this, understanding who may be involved, getting them interested, getting them to the point where they understand the benefits of information sharing is always key. And it doesn't matter what jurisdiction those other parties are in, providing they can be persuaded and they can see that there's a relevance to the information they hold, then they should be able to come on board. So yeah, don't fear the foreign jurisdiction. And get into it, make friends, and then see where that will lead you. Good.
Absolutely correct. And I agree with that thought exactly. And don't expect, though, everybody to do things the way you do them.
Yes.
Because there will be differences.
Well, thank you, Geraldine, for joining. That
You're
was
most welcome.
A great little ramble through the US and UK distinctions. We could have gone into that in a lot more detail, I suspect, and maybe we'll come back to the nuances of claims that can be brought in the different jurisdictions and which one's the best one to litigate in. Thank you to everyone who is listening to Dodging Bullets. Please keep on commenting. We're always open to new topics, ideas, guests, and hosts. So if there is a burning desire to share your experiences in an area which perhaps doesn't get enough of an airing through more conventional channels, please do get in touch. But otherwise, this has been Dodging Bullets.